All right. All persons having business before the honorable associate judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its on the court. This on the court is now in session. Please be seated and come forward.
Take off my glasses to read. Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. The first case is 19 CO 745, Kevin M. Bellinger versus the United States. So counsel, if you'd like to come to the podium and let us know how much time you would like for rebuttal and introduce yourself.
Thank you, Your Honor. Does this go up?
It should. There should be a button on the side.
Yes, not.
On your left, perhaps?
I think that's where it is. I think you're close to it.
Yes.
No, I'm pushing it. I think it's just not going up any further. So I'll make do. Thank you. Good
Hold on.
morning, Your
The
Honor.
clerk might help you. The bailiff might help you. Thank you. It's not working. All right. If we could make a note of that. Thank you. Maybe if you could just direct your microphone a little bit. Yeah,
There we go.
you go.
All
Thank
righty.
you.
Thank you.
Appreciate it.
Good morning, Your Honor, and may it please the court. My name is Michael Anstedt, and I'm here on behalf of the appellant Kevin Bellinger. I'd like to reserve 2 minutes for rebuttal, if I may. And one additional preliminary matter I wanted to raise with the court. There are certain materials in this record that are under seal that could be part of the discussion that we have today in the courtroom. I believe that the parties in the court can address those sealed materials in a way that maintains the reason for their seal. So I just wanted to alert the court to that. And if there are any questions that really do speak to those sealed records, we'll have to find a way to address them in a non-public forum. Mr. Bellinger's convictions are the direct result of two failures of the criminal justice system here. First was the government's suppression of exculpatory evidence in violation of its Brady obligations. That evidence would have supported a third-party perpetrator defense. And relatedly, the second issue and second failure was Mr. Bellinger's trial counsel's failure to investigate and then present evidence that would have supported a third-party perpetrator defense. Therefore, depriving Mr. Bellinger of his constitutional right to effective assistance of counsel. Despite the compelling evidence before the trial court that undermined the validity of Mr. Bellinger's convictions, the trial court denied his motion for a new trial. And as we explained in our briefs, and as I'd like to discuss further with the court today, in denying Mr. Bellinger's post-conviction motion, the trial court misapplied the law, ignored key facts, and unreasonably credited the implausible testimony of one of the police investigators in this case who was involved in the Brady violation. And because of the record establishes these two constitutional violations, Mr. Bellinger's convictions should be vacated. There are many issues that have been briefed in this case. I'd like to start, if I may, with the Brady issues and the Brady violation. The Brady violation is, subject to the familiar elements that the evidence at issue must be favorable to the accused. It must be suppressed by the state or the government, and prejudice must have ensued. And as this court has recognized, one of the important purposes of the prosecutor's obligation under Brady is to allow the defense to the opportunity to investigate the facts of the case and to help the defendant craft an appropriate defense.
So we know that the government has no duty to investigate. And so I think the sticking point for me is, how do we know the government had this evidence, knew this fact such that it needed to turn it over?
Sure. And so I think the facts that the government knew were the connection that they had the ballistics evidence for both of these shootings, the Rivers homicide and the Jackson shooting, correct? They had the casings. The only thing that they didn't have, which is what we got as part of the post-conviction process, was the actual match, the forensic match by the expert who did that. But the police had everything else. They had a suspicion. They were talking to all of these same members of the 18th and D Street gang.
I mean, counsel, we've sort of addressed this argument before in 2015. And what we said there was having clues that if pursued could have led to discovery of exculpatory evidence or information is not the same as actually having the exculpatory evidence. And what we said roughly in that 2015 opinion is if you can go back after a hearing and show that the government knew there was a match, well, that's one thing. But if instead all you're saying is what you're saying in 2015, which was all the clues were there for them to put this stuff together, and that is the Brady violation, that strikes me as an argument that's foreclosed by our prior opinion.
Well, I understand your Honor's question, and I think that the difference in what the court said in the prior opinion and where we are today is that in the prior opinion, the court actually left open that possibility, as you mentioned, that there could be further evidence. And where we are now is we do have that evidence. We have that evidence from the incredible testimony of Detective Horn. She testified that, I mean, I'm in a funny position because honestly, there's some evidence or some testimony of hers that I think is absolutely credible. The credible part of it is that she was interviewing my client in his arrest interview and asking about the Mack shooting or asking about Randall Mack, asking about Patrick Andrews, asking about other shootings that took place in this neighborhood around the same time by the same people. But at the same time, her testimony that the city was just too crime-ridden for her to possibly have made the connection with the 4 police officers who were together on this task force investigating and responsible for the crime, the violent crimes in this neighborhood, that these 4 people who are talking to each other, who are interviewing all of these suspects, don't have any reason whatsoever.
No, I mean, they might have,
this.
I guess my question, counsel, though, is they might have all the reason in the world to connect it. But I think what we said in 2015 is having reason to connect the dots. It's not the same thing as having connected the dots. And only when you've connected the dots does a Brady obligation arise. Do you think I'm misreading the 2015 opinion? Or do you think that that you had the evidence that the dots were connected here?
What I would submit, Your Honor, is that the evidence, the testimony from Detective Horn connected the dots. That's the testimony that she provided, which I mean, granted, she disavowed any knowledge or any connection, but our submission is that when you read that testimony and you take it as a whole, it's just not credible. It's just not plausible.
Counsel, there's another difference between what you had in 2015 and what you have now, right? You have Detective Horn's testimony, but there's been a clarification of the law that actually nobody has talked about in the brief. So in case you're not aware, we have a couple of decisions out of this court that talk about pattern matching in ballistics evidence. And it says essentially that you can't put on an expert to say that there is a match between a gun and tool mark evidence, right? And tool marks on bullet casings. And so I'm trying to figure out where that leaves you. If this court has said that the data is not there to allow an expert to testify that you can match with any certainty a gun to a bullet, I don't know that you have any exculpatory evidence anymore, right? I mean, you have a 2006 report from a forensic examiner saying there's a match. But this court has looked at the data and said, that's not reliable science.
Sure.
No one's mentioned that. And I'm curious to know why it hasn't come up in your briefing, and I'll ask the government the same.
Well, I think that one, I mean, we're in some ways working from the state of facts as they would have been back then. And at that time, that certainly would have been able, Mr. Bellinger's counsel would have been able to use that evidence. I understand that.
I understand that, but that's deeply unsatisfactory, right? I mean, maybe ballistics has sort of the residue of sort of reliable science, but think of something more fantastic, right?
Sure.
Think of, the proposition that the police can feel someone's aura and figure out that they're the guilty person.
Sure.
And, you wanted to put on evidence that the police could have felt this person's aura and figured out that they were guilty. And you just never got the aura evidence, and your lawyer the trial lawyer never asked for the aura evidence. And so here you are making a Brady claim and an ineffective assistance of counsel claim, but we've issued an opinion saying that's not real, right? You
Sure.
can't feel someone's aura and figure out whether or not they're guilty. So yes, we could say we're going to look at prejudice at the time of the conviction, but there's the reality that if it's not science, it's not science. And I'm not quite sure what you would do on remand if we have said that this isn't not proven to be scientifically valid yet, is I think how we left things in Williams.
No, I understand that, but I don't know that the Brady standard requires that the evidence that is being suppressed be admissible in court. It has to be evidence that the defense could have used to develop a defense.
So explain to me how you would have used invalid scientific evidence to develop a Winfield suspect.
As I understand it, the scientific evidence is that it's not totally reliable, but I don't know that it is. Perhaps it's not totally incredible that there could be a match. And that what I'm saying is that in this circumstance, even at today, the counsel could use that connection, whether they can, introduce it in court. They could use it to pull that thread.
The science is that the tool marks have not been demonstrated to be unique, right? So that there's no ability to make a definitive identification, right? You can say, gee, these things look similar, but who knows how many other bullets fired from different guns also look similar. So it maybe is of some minimal utility, but not even then, because guns change over time and, different things can cause different tool marks. So that's the state of the science, at least as we understood it to be when we wrote the Williams opinion.
Yeah, understood. But I think maybe step back. I've gotten myself in a bit of a hole on this question, and I apologize because in stepping back, what I would say, Your Honor, is that, sure, like we have this ballistics match and we've used that through through this case, but really the issue is that this gun was used by. Our theory is that this gun was used by somebody else, because this is the only evidence that connected my client to this shooting was the victim's testimony, and the victim was not a reliable victim on that point, which the 3 trials would help to illustrate that. So the ballistics evidence confirmed back then for us that that the guns matched, but the fact that the police in this instance knew or should have known or suspected and just didn't go far enough because they were willfully blind to it.
It seems like you have 2 problems. One is whether they actually knew, and then 2, what was the utility of what they knew? So taking the first in your favor, let's say that a psychic had come to them and said, I know Mr. Bellinger didn't do it because Mr. Jackson did. We know we don't trust that, right? Is that somehow material evidence that by withholding what the psychic said from the defense, you've committed a Brady violation?
No, I would not agree to that. But here the police suspected that the police knew it was the police's position that these guns are passed amongst all sorts of folks. The police were in possession of they knew that Mac had this gun, that he had told them in his arrest interview that Andrews had used the gun. The gun was hot and had been used by Andrews in a prior shooting. The point here is that the police officers they knew that these were all related. They were investigating the same people in the same neighborhood for the same types of crimes. And they just willfully were blind to the fact that there could be that this gun could have been used by Mac instead of by my client.
One other slightly odd thing about your Brady claim is you have maintained that trial counsel did in fact know to some degree about the ballistics match.
Yeah.
And I agree there's something fairly unsatisfying about how Judge Cannon breezed by that. He said, oh, we don't know exactly when she found out, but she knew by the time she handed over her trial records to post-trial counsel, which was just a few weeks later. So it seems like a fair inference that trial counsel knew about the ballistics match going into that third trial, which
case it's not a Brady violation.
well, I don't know. I guess my question to you is how does that reconcile with your Brady argument?
Well, I think one, counsel was not privy to all of the evidence in the investigative material that the police had. She did not have access to Mac's interview transcript. She didn't have the casing. She didn't have any of the evidence that she might have been able to use to pull this thread that the police had. She just had the atmospheric knowledge that everybody else seemed to in the courthouse seemed to have had. And the reason why she was actually in the case in the first place is because the PDS had to withdraw for this reason, which everybody seems to have known. So yeah, I understand it's a little bit of a double-edged sword for us, but we are where we are. And the problem is that either the police withheld this evidence that was material and exculpatory, or counsel was deficient in not pursuing this.
So it's just that the arguments are, in your view, they're in the alternative, really. If Miss Barron, if she was aware of the match, more or less, then you're really in the ineffective assistance of counsel. Like if we find Judge Cannon's rejection of that posited fact to be clearly erroneous, that, you know, all signs point to the fact that she did know about it, then we're kind of in ineffective assistance of counsel territory. Is that right?
I think that's right.
Okay.
Yeah. And, you know, again, the Strickland standard is an objective standard, so we don't need Ms. Barron's testimony to know what she would have done or what she could have said that would have, how she would have justified, you know, her actions as strategic. I see my time is up, so I will.
Actually, I have a couple of questions on ineffective assistance of counsel, if you don't mind me keeping you up there for a minute. I mean, at points in your brief, you say, you know, really, if she knew about this, there was no conceivable strategic reason not to use it. And I almost think that might be the burden that you need to carry, because we just don't know, given her passing, whether or not it was strategic. But if she knew about it, it seems like a pretty fair inference that it was strategic and not just simple oversight. Or at least that's something that, given your burden on an ineffective assistance of counsel claim, we'd have to draw that inference against you. But I can think of a couple reasons why counsel would strategically want to stay away from this. And let me get your opinion on two. First, is the extreme likelihood that Mr. Mack is locked up at the time of this shooting, making him a very bad candidate for a Winfield defense. Because if the government could come forward and say he's locked up at the time, not only have you lost your Winfield defense, but you've kind of, you know, I think trial defense counsel will tell you when you put on a Winfield defense, you've kind of taken a burden on yourself. And if you can't actually substantiate your Winfield defense, it makes it a lot harder to win a trial. So why wouldn't that be a strategic reason why Miss Barron would try to stay away from this? That Mac just wasn't around.
Yeah, I think the answer is in the record, and it's in the sidebar that she has with Judge Cannon in the third trial, where she specifically disavows making any Winfield defense. And she does that in the context of she's going down the road. She's asking questions about Jackson and that she's an informant and that there are others in the neighborhood who didn't like her. And the government stands up and objects to all of that line of questioning. So there's a sidebar and the judge says, where are you going with this? And she says, I'm not going with a Winfield defense. Like the evidence there is, I mean, like, I think the record is clear that she just didn't do the investigation. She was trying to get to a Winfield defense without having done any of the investigation.
But can't you read that as she's done the investigation and she affirmatively knows that because Mac was unavailable, a Winfield defense is not on offer?
But there's no evidence that she did do any investigation. Her investigator stipulated that he didn't do any investigation for her. I think that the record that we have and to be honest with you, I think even if she had done any investigation, I just can't conceive of a reason why she would not have gone down this road. Because if it wasn't Mac, it could have been any one of these 18th D Street gang
Well,
members.
I mean, that's a perfectly good point. But I mean, we know, I think based on the government's motion in limine after the first trial, that the trial court, rightly or wrongly, was not going to allow the sort of could have been anybody defense. So that's one reason why, you know, we can't really hold that against Ms. Barron. It's been precluded by the trial court.
Yeah.
Okay. And the other thing that I was going to ask you about is, you know, there have been two trials. Mr. Bellinger has a handful of alibi witnesses who seem to be persuasive to the first two jurors, at least half in the first and, you know, 10 out of 12 in the second.
Yeah.
One reason to steer clear of this Winfield evidence would be it's going to open the door to a lot of evidence that Mr. Bellinger is in bed with the 18th and D Street crew, that he's affiliated with, you know, Andrews and Mac, and it's not going to be that powerful once you not only can the government take the sting out of this by saying, yeah, crews share guns, that's not unusual, but they can also then kind of paint your client with this big propensity brush and say, and this guy is also a bad guy and he's dangerous. Even, you know, no matter what you think about, you know, there's always the risk that a juror is going to convict somebody, even if they think he's innocent, if they think he's in neck deep in a bunch of other bad stuff. So that's the type of thing that a defense counsel might want to steer clear of. Do you think that couldn't be a strategic decision?
Here, I don't think so, in the sense that in Mr. Bellinger's testimony in the evidentiary hearing for this case, you know, he testified that he was not part of this 18th and D Street gang. He was familiar with them. But he was not part of this neighborhood in the same way that Andrews and Mac and all these others were. And I think that, you know, we can speculate as to what the government might have been able to put on as counter evidence had Mr. Bellinger's counsel pursued this third-party perpetrator defense, but it's hard to know how. I mean, we're in like hindsight on top of hindsight, and I think that that's not the standard that we need to establish on our end to demonstrate a Strickland violation.
Thank you,
I'm
counsel.
way beyond my time.
No, well, we invited you to stay up here for more questions, so no apology necessary. We'll give you more time on rebuttal, but now we'll hear from the government.
Morning. May it please the court, David Sable on behalf of the United States. I apologize for the mask. By the time I got my kids off to school, I had forgotten all about the COVID test.
Happens to the best of us.
I'm sorry?
It happens to the best of us.
Yes. Judge Cannon did not abuse his discretion in denying Mr. Bellinger's 23-110 motion. And first of all, I just want to touch on the latches because we haven't talked about it. Judge Cannon found without clear error that in 2009, two things happened. Phyllis Barron died, taking with her not only what she did in investigating, but also what she knew and what decisions she may or may not have made. And the second thing that happened was terraces closed and those records ultimately became unavailable to the government. So although Judge Cannon was able to say, most likely Mac was locked up at that time, that in that place, couldn't say it for sure. And that happened because Kevin Bellinger decided not to file his 23-110 until 2011. The ex parte motion was filed by Jenny Wicks, proffering the ballistics match in 2002. Fried Frank got involved in 2004, filed another motion. In 2006, the match was confirmed and nothing materially changed from 2006. And in fact, if you look at the briefs from the direct appeal that resulted in the MOJ, this issue is in the briefs. It's in the briefs. And then Phyllis Barron dies in 2009. And at that point, for the first time, Mr. Bellinger says, falsely according to Judge Cannon, oh, Phyllis Barron told me about this match. She said she was going to file a motion. This was, according to Judge Cannon, a bunch of lies. He says that after she dies for the first time. This is a laches case. It should be applied in this case. It was a finding by Judge Cannon of material prejudice. And on that ground alone, the motion should be, the judgment should be affirmed.
So I'm not sure how to think about the material prejudice prong. I mean, it's kind of we don't know. We don't know what would have happened. We don't know if Ms. Barron's testimony was going to help you. We don't know if it was going to help Mr. Bellinger. So is it just we draw all inferences against the heel dragging party? Is that how you think it works?
I wouldn't be prepared to say that. I think we have findings by Judge Cannon that were not clearly erroneous, and we have.
Oh, it's certainly. I mean, you can totally discount Mr. Bellinger's story about him, Miss Barron knowing about it and lying to him. I mean, that's all just, those are all credibility findings. We don't even need to get to the delay, the latches argument to say Judge Cannon made perfectly fine credibility findings that, Mr. Bellinger is making that stuff up about Miss Barron. But there is other evidence, right? There's Miss Wicks saying that Miss Barron knew about the ballistics match coming into trial.
Right.
What do we do with by the time she handed off the file? And what do we do with that? Exactly.
And just on the latches briefly, Your Honor, I think fairly, if you look at Judge Cannon's order, which is an amazing order, he did not draw inferences one way or the other. He's just looking into facts, calling them as he sees them. But on the Jenny Wicks testimony, so the evidence, we're talking about deficiency now. The evidence on deficiency was PDS withdrew, right? Christian Lamar tried the case. He withdrew after the first trial because obviously they represented Max, so they knew about the match. There's no evidence they ever told Phyllis Barron about it. Jenny Wicks knew in 2001, Patrick Andrews told her Kevin Bellinger shot Lorraine Jackson with the gun the police got from Mac. She knew that in 2001. Jenny Wicks didn't tell Phyllis Barron. Nobody told Phyllis Barron. The government didn't know about the match. They hadn't done the test. It didn't fit their protocol to do the test. We didn't know. Prosecutors didn't know. Jenny Anderson, Glenn Kirshner didn't know. So if Phyllis Barron knew, we'd have to speculate. We're speculating now. But obviously Bellinger told her, right? Because he was in the same crew. He gave the gun to Andrews after he did it. I don't know how that establishes deficiency. I mean, if Phyllis Barron knew about it, then she probably made some tactical decisions in that regard. But again, we don't know this. And I do want to make one point, which is that Judge Cannon found there was no evidence. They had not shown deficiency on the ground that Phyllis Barron knew about the match and didn't act on it. But there's another claim that appellant is making now, which is even if she didn't know about the match, she should have done more investigation, kind of a co-seal argument. That was not presented below. Judge Cannon didn't have a chance to make findings on that. It's not properly before this court. I just want to make that point because I think it's not fair because we don't know everything that Phyllis Barron did or didn't do. I don't even know if she had a second investigator.
So, I mean, this is interesting because this sounds new to me. Did you point out that they didn't make this failure to investigate argument below in your brief?
Yes, yes.
Can you just tell me where?
Patty pointed it out.
I don't mean to derail you. I mean, I'm happy to, maybe your second chair can look it up while you continue on.
I'm easily derailed.
I just don't recall it.
It's in a footnote, Your Honor.
Okay.
I will make
sure. We'll look for it.
Okay.
Can I ask you though about this match? Right. I mean, because you're alluding to other ways that people might have known that the same gun was used.
I actually, and that's for this argument, you get mad at me for saying the word. And I was like, what am I going to say to Judge Easley? It doesn't use the word match.
Right. So we might have other ways of knowing that the same gun was used, but is the government conceding? Well, I guess, is the government conceding that the 2006 test is valid? And can the government concede that the 2000 ballistics test is valid in light of Williams and Gardner? Right. I mean, I guess just to put a finer point on it, say we agreed with Mr. Bellinger and said, you're right, remand, right, to reverse, and they want to put on a Winfield evidence. Are you a Winfield defendant? Is the government stuck with a match based on what this court has said is flawed forensic science? right? And does the court have to accept it just because the government hasn't argued it? I find ourselves in a very strange position right now.
Well, with all due respect, Judge, this really isn't an issue that this court even comes close to having to reach in this case, because as Judge Deal said, this court decided the Brady issue in 2015, and the facts materially haven't changed on Brady. They really just haven't.
But the Brady issue was premised on an understanding that there was such a thing as a ballistics match, right? I mean, I think we used those words in the Bellinger opinion in 2015. Williams and Gardner come later. So I understand that the
understand.
government doesn't think that we need to get to this, but I am curious to know what the government's position is. Is the government waiving? Has this been waived? And has it not just been waived for this appeal, but for any future litigation such that a trial court would have to admit evidence of a match that this court has said is based on flawed forensic science?
Well, again, I'm not in a position to waive anything about ballistics, which it's not briefed, it's not before the court. My understanding of Williams, I've read, what you've written, and I understand it to be a level of certainty issue. And so, I mean, I guess we could argue about if there were a retrial, would the evidence come in on the level of certainty issue, or would he be entitled to the law as it existed in 2002? I couldn't even begin to tease that one out.
Well, look, it's a
But what I
slightly
do know
separate
is,
question is, are we looking at materiality as of the time this evidence was allegedly withheld, or are we going to look at it with the hindsight of what we know now?
we would look at materiality as of the time that it happened, obviously, because if Phyllis Barron had had this information and if she had elected to pursue it, we know that the government had all this weapons information from Mr. Bellinger's bedroom. It had this poem celebrating the violence, had the testimony about guns being shared and kept in stash locations at 18th and D.
But just to stay on the ballistics.
And the terraces information, which we presume for the purposes of the analysis, Judge, would have still been available because it was 2002. They were still open.
Right, but
And
we're
so
staying on the ballistics, which I believe
Okay.
that my colleague was also pointing to, and to take her hypothetical of the psychic, right? Say in 2006, everyone believed that psychics gave reliable information, right? And the government had information from a psychic that Mr. Mack was the shooter. But we now know that information from psychics is not scientifically reliable, right? But the government hasn't argued before us that information from a psychic is just not admissible in court. So here we are, and the defense is saying, I have a Brady claim and an ineffective assistance of counsel claim because
I
the
understand.
government had evidence from a psychic. And I'm wondering, is the government's position truly, well, we're not going to argue that the evidence from the psychic is invalid on appeal, and were there a reversal and a remand, the defense could put that evidence on. Is that the government's position? And I know you don't want to answer that, but it just seems like this case does seem to present the question.
Oh, I don't. I have to go with your assumption, your hypothetical, but no, I don't. For all the reasons that we set out, I don't think this case presents that, because I think the terrorist's record, I'm not even sure this defense would have been admissible. But I mean, at the time, I would think that we would have to go with what the law was at the time, because that is the way this case is briefed, and that is the party's understanding is what could the government that has to do with. This court sent it back to Judge Cannon saying, denied the Brady claim, was inclined to deny the ineffectiveness claim, but said, look, we need some factual development. You did a summary judgment. You didn't do a hearing. We want to hear more about what would the government have done on rebuttal if Phyllis Barron had presented a Winfield defense. We want to hear more about that. And by the way, if you find out some evidence of deficiency, we're open to rethinking that. I know we want to hear more about that. They didn't deny the deficiency, but they denied Brady.
But they allowed more discovery on Brady.
They allowed more discovery, and we have it. And the Brady analysis hasn't changed. It just hasn't changed on the facts, Your Honor. On the facts, it hasn't changed. So you don't even get to what would happen, because the court found The government didn't do the test. There was there was a protocol.
Right, and I get that the facts haven't changed, but my point is that the law has changed. And it's just curious that the government isn't arguing that the law has changed. And I just am trying to figure out where that leaves us.
Well, I understand the law to have to do with degree of certainty. We still use ballistics evidence
Well,
all the time.
the degree
and-
of certainty in this case, I mean, if you look at the report from 2006 was 100% certainty. It was, there is a match. There was no qualification. It wasn't, I'm 98% certain, or I'm, certain to a scientific degree of certainty. It was just these two things. This bullet was fired from this gun. It was total.
I understand. So there's a small delta that you would have here. If we did the analysis in 2002, it's 100% certainty it comes in. If it goes back on remand, it's not scientific certainty, but it still comes in. It doesn't make a difference. It just doesn't make a difference. Phyllis Barron would never have let this gang evidence come into this case. She had 10-2 to acquit after the second trial. She had a recanting witness. If the gang evidence comes in, it changes the whole pallor of the case. It's incredibly unfair, prejudice to the defendant. She would never have let it in. He's trying to kill a woman because he thinks she's a snitch. She's not going to let in all this evidence that he was a crew member, that they celebrated violence, that they shared guns, that they passed around the guns, that he had a prior CPWL. There's no way. If I could just turn to the strength of the evidence, which goes to the prejudice and also to the materiality in both cases. Again, this court said on direct appeal that there was one issue, which was identification. The evidence of identification was unusually strong. Lorraine Jackson is shot 4 times in the alley. She says, "I know who you are." The resident manager of the apartment building hears this. And he testified only in the third trial. He hears this and he recognizes her voice. The police officer shows up and says to her, "You don't look like you're going to make it."
See, if I find that statement to be so curious, "I know who you are," almost sounds like the person is disguised, which is something that Miss Jackson told somebody else, right?
Oh, it's a darkish alley.
The dark. I thought somebody else said that, reported that there was a witness who said Lorraine Jackson told her that her assailant's face was covered.
I think that's a defense. That's a defense witness.
Right. Okay. But
Whether that's credited or not, I have no idea.
okay. Yeah, "I know who you are" is sort of a strange thing to say to somebody, rather than, "I know that's you, Kevin." "I know who you are" sort of sounds like they think they've hidden themselves. Because he was right. He was right. My understanding was this shooting was from 6 feet away. I mean, it just sounds to me like not the most powerful thing in the world. It sounds to me like she's talking to somebody who has their face covered.
Well, again,
Well, I take it there's other strong evidence, but just a minute ago you mentioned how this was a 10-2 for acquittal in the second trial was everything but that little bit of somebody else overhearing the statement.
well, there were 3 things that happened in the third trial that didn't happen in the second trial. One, Jackson's niece, who didn't like her. I'm not going to get her name right. She identified, she said that Bellinger confessed to her, and then she spun the government on the stand, right? And then there was the resident manager who recognized your voice and said, "I know who you are."
Actually, just pause on that for a second. I missed as far as I thought that was her grand jury testimony that Mr. Bellinger had confessed to her. Is that right?
Exactly.
And that wasn't introduced in the first or second trial?
It wasn't in the second trial.
That's it. Huh. I didn't know that. Okay.
Okay. So, and it comes in for the truth of the matter asserted. And again,
It seems like a shocking thing that the government wouldn't put in at the second trial.
well, you need the witness. I don't know if they had the witness.
I see.
You can't put it in without the witness. And in a gang case, the most powerful witnesses are the ones who spin the government, because obviously the juror's like, "Well, I'm gonna be afraid of that guy too."
Mhm.
Right? So that's another reason why Phyllis Barron wouldn't let that evidence come in. And the third witness who testified in the third trial that was not in the second trial was the license plate guy. The license plate guy who said, "Yeah, I saw that car," and Bellinger's associate was driving around with the car because they were using the car with the stolen license plate. So that car was associated with Bellinger, was seen driving away from the scene at high speed. 2 guys are seen getting out of it. And then Then you have the confession, and then you also have the fact that he, cuts off his dread and shaves his head within 2 days.
I think I steered you off of latches very early on. So I just have two questions for you about latches before we wrap up.
May I basically make one point?
Oh, yes, please.
Sure. And then Judge Farron in his concurrence in the 2015 case says, yes, okay, we're remanding on ineffectiveness, but even if this comes back, I want to let you know, it's very unlikely that the defendant is going to be able to show prejudice on these facts.
On latches, what do we do with the government's 4-year delay in turning over the ballistics evidence? Because I mean, look, if you subtract that out from when they filed their claim, then we're in 2007 and Miss Barron's alive and the terraces are still open and all that evidence is there. And I think one argument Mr. Bellinger's counsel is making is you're not really in such a good position to be making a latches type argument when you ignored a court order to turn over this ballistics evidence for 4 years. And that was nearly half of the delay.
Well, if you look at the evidentiary hearing record, you'll see that each party made different proffers about what happened during that 4-year period. Judge Cannon didn't make findings. And so unless you're going to make those findings here, you can't do much with it, I would say.
Yeah, I saw that in the briefing. Could you just tell me what the government's explanation for the 4-year delay was?
I was about to, yes.
Sure.
So we said that at least for the first 2 years, he hires Jenny Wicks. He can't pay Jenny Wicks. Because he's not paying Jenny Wicks, she's not retaining an expert, she's not getting the evidence. That's the first 2 years. Freed Frank comes in 2004, they make a supplemental motion for the evidence, and then the government files a motion, and the government says we turned over the ballistics evidence in January 2006. Their expert says, no, I didn't get it until September 2006, but then the report is the fall of 2006.
Yeah, none of that really answers my question, though. I mean, it's January or the fall of 2006. But whether or not Jenny Wicks was getting paid or not, how does that preclude the government from handing over the raw materials for the ballistics testing?
It doesn't, but she has to go get it. She's not going to go get it if she's not getting paid.
She has to go. So
she has to get it.
It was there available to her, but she wasn't picking it up. That was the government's position.
The government's that she wasn't trying to pick it up. We don't know if
she had a court order for you guys to turn it over, right? I thought she had a court order in 2002 telling you all to turn it over.
Exactly, they did, August 9th of 2002, but Jenny Wicks has to go get it. Nobody said, Miss Wicks, she testified. Why didn't you go get the evidence on August 10th of 2002? Presumably she's not going to get it until she hires a firearms expert. She's not going to do that unless she gets an order from the court paying for it, or Mr. Bellinger can pay for it. I don't know, Your Honor. I'm just telling you what the prosecutor said below.
No, that's helpful.
And Judge Cannon felt like, oh, this isn't what's relevant. And I want to direct the court to the statute.
I mean, Judge Cannon just kept on referring to it as a 9-year delay, which struck me as being pretty unfair.
He said at the beginning it was a 9-year delay from the proffer of the possible match, but the relevant period he found was 2006 to 2011. And what does the statute say? The statute says, material prejudice, unless the movement shows that the motion is based on grounds which the movement could not have raised by the exercise of reasonable diligence before the circumstances prejudicial to the government occurred.
I guess my second question is,
and 2009
right,
is the year.
And yeah, my other question was about, that amendment adding that sort of latches provision into 23-110 was passed in 2009. And one argument that Mr. Bellinger is making is, well, you can't really hold the pre-amendment delay against us. This was like a new thing. And then we acted reasonably. And by the time this latches provision was put in the statute, Ms. Barron's already dead. The terraces is already closed. All the prejudice was like a pre-amendment type prejudice. What's your reaction to that?
In Bellinger, in fact, this court talked about the latches provision as if it could apply. Again, it wasn't teed up, but it was mentioned. Secondly, the latches provision in 2009 is very similar to the Rule 9A, which is in my 28K letter. So in the federal context, in 1977, they adopted Rule 9A, which said the same thing as this latches provision. And it was ultimately repealed because we had EDPA and there's a one year deadline. But so we have a bunch of cases from late 70s, early 80s interpreting Rule 9A that are applying it in the exact same circumstance. Convictions before 77, things that arose before 77, motions filed after 77, and then they're precluded by the Rule 9A latches provision. And so that's what we cited to the court. And finally, I would just say this. You know, Rule 9A, and I assume this latches provision, were codifications of the equitable remedy. Now, we know that previously, yes, the statute said a motion can be filed at any time. So the equitable remedy without a statutory hook wasn't enough. So if that was the case, but the equitable remedy had been around for a long time. And this court said in Ramsey that even if, and Ramsey was 1990, we didn't have the latches provision. The court said in Ramsey, yes, we're not going to preclude the motion altogether based on latches, but we can consider it when we look at the credibility of the defendant's claim. And that's what Judge Cannon said here. And that's what he did. And so that's a thumb on the scale for the government here, given the gross unfairness. And again, I just want to say, if you think it's okay for him to wait till 2011 just to file the match evidence, that's one thing. But waiting for Phyllis Barron to die and then telling lies on her, that's not right. That's not fair. And none of that evidence is in front of this court because Judge Cannon found he was wholly uncredible and not worthy of belief. So those credibility determinations with respect to Detective Horn, with respect to Mr. Bellinger, as this court's well aware, they're virtually unreviewable on appeal, and they're very well supported in the record. If there's nothing further, I'd ask the court to affirm. Thank you.
Thank you, counsel. Mr. Anstett, we'll hear from you for just a few minutes.
Your Honor, may I just point out to the court, in response to Judge Steele, I think we're talking about page 41 of the government's brief, footnote 19.
In regards to, sorry.
The waiver.
Preserving the
Thank you.
claim.
Thank you very much. Appreciate
Thank you.
that.
So, Your Honor, let me start there. As I read the government's footnote here, they're saying that we did not preserve a general third-party perpetrator defense, and therefore it's all been made. I just feel like the government's splitting hairs there. We've been arguing the whole time from the very beginning when we filed our motion that the judge or that Ms. Barron did not pursue a third-party perpetrator defense, and that our arguments included not just Mac, but all the other members of the 18th and D Street gang. So I just don't understand what the government's point there is. If I may, I'll touch on the delay and latches argument. And the court is already raised for us the point that the government's delay contributed substantially to this 4 years of delay under 2 court orders. And the timing of the latches provision that was codified by the DC Council comes after all of these things that the government says are now materially prejudicial.
But Ramsey predates the latches provision by like 20 years, doesn't it?
But well, Ramsey says that the impact of a delay that is, that is not explained and has material prejudice to the government is that it will go to the credibility of the claim. Frankly, in this case, there are very few facts that are not like agreed upon. It's just a matter of like how the court and the parties understand those facts and what the legal consequences of those facts. So, the credibility of the claim, I don't know what that means in this context. If the facts are the facts, it doesn't really undermine the credibility of the claim that we've argued all along. That
Well, it could certainly undermine things like Mr. Bellinger's testimony that Ms. Barron knew about the ballistics match. She said she filed a motion. The
Sure.
government wouldn't turn it over. All that stuff
Sure.
would under Ramsey be discountable.
Discountable perhaps, but we also had all the other evidence that we put in that corroborated. And our argument from the very beginning has been its objective standard. So it doesn't matter what, somebody, counsel might have been able to testify to. I just don't think that the government and these facts has been able to establish material prejudice to its case.
Why not? What about the terraces? So, I mean, here's one finding by Judge Cannon. Mr. Mack, all signs point to Mr. Mack was in the terraces at this time. If true, his weekend pass, he was on weekend passes bi-monthly at that time. If it was ever outside of a typical weekend, there had to be a motion. There was no motion here. And so all signs point to Mr. Mack being a non-viable Winfield because he was locked up at the time. And while we can't say for sure because we don't have records from the terraces, that delay needs to be, the delay in filing is the reason why we don't know that information. And it seems most likely that the terraces records would have foreclosed a Winfield defense. And so I'm going to hold the delay against Mr. Bellinger. I think that's something of what the trial court's analysis was. I'm not sure. You look like you disagree.
I understand. I disagree in the sense that I don't know that the records that the court did have foreclosed that possibility. I think they're at best they're in equipoise. Like we don't know we can't prove one way or the other. We have to live.
Well,
we as a defendant have to live with that fact.
The trial court certainly did not say that they were in equipoise. The trial court's finding, I mean, the trial court said at least, as best we can tell, he was locked up at the terraces at the time. It is not ironclad, but the reason we don't have any ironclad evidence as to whether or not that's true is because this was a really delayed 23-110 motion. So I guess I don't know. I mean, isn't it always true that if somebody delays and evidence disappears because of it, like you don't know what that evidence is going to show, that doesn't mean that it's in equipoise. If you're going to read material prejudice under 23-110 as doing any real work, isn't it kind of cutting inferences against the delaying party?
Well, I think that you can cut an inference, but that's not a basis for dismissing a 23-110. Ramsey says that you can take it into account for credibility purposes and you can weigh that. And I'm stuck with that if the court wants to weigh whether or not this part of the claim is credible or not. But that's not the same thing as providing what this new statute added in December of 2010, or 2009, which is that the case can be dismissed. And Judge Cannon didn't purport to do that. Again, the remedy under that provision is to dismiss the claim. And here we're only talking about the ineffective assistance claim. This argument has nothing to do with the Brady claim. And the government hasn't argued otherwise. But if I lost my train of thought, so I apologize. But I think the point is that the 2009 change, we shouldn't be charged with anything that happened before then. It's unfortunate.
Yeah, I wonder if that's right. In 2009, when of the DC Council have been free to remove 23-110 as a remedy entirely? They could have just said no more 23-110. You don't get to bring this claim, period. So I mean, why? I think the general presumption in the law is that legislation is presumed to have retroactive effect. And so even if it smacks of some unfairness for you to have been to count the pre-amendment delay against you, the council didn't suggest discount any pre-amendment delay. It seemed to speak quite broadly. So why wouldn't we hold the pre-amendment delay against you?
Well, I think part of the answer then is that if you have to look at our delay, then you have to look at the government's delay and you combine those together. And I think that we both the government doesn't come to this court for that equitable remedy with clean hands. All right.
Do you have any closing words?
Mr. Bellinger's conviction should be vacated. Thank you, Your Honors, for your time. Appreciate it.
Thank you, counsel. And I specifically want to recognize your service to Mr. Bellinger over the years and Fried Frank's obvious investment of extensive resources. So thank you very much for that representation. Thank you to the government for its argument today, and the case will be submitted. The next case on our calendar, it's actually two consolidated cases, 21 CV 408, Desiree Williams versus Rajesh and Sadhna LLC. and 21 CV 418 Rajesh and Sadhna LLC versus Studio 3877 PLLC and New City Construction LLC.
Good morning, Your Honor.
Good morning. I do have housekeeping questions, or actually a proposal to which you can respond, but my plan was to allow Mr. Hartnett to argue for Ms. Williams to start, then to allow Mr. Heyman to argue as appellee and cross appellant, and then to have Mr. Shoemaker argue as cross appellee, and then go back to Mr. Hartnett. Does that work?
Yes, Your Honor.
If I may speak to that, Your Honor, we've agreed with respect to the cross appeal to submit on the papers.
I see.
Respect to all parties to the cross appeal.
Great. Well, that works too. Thank you. So we'll start with you, Mr. Hartnett, and if you could introduce yourself for the record and then let us know how much time you would like for rebuttal.
Good morning, Your Honors. My name is Thomas Hartnett. I represent the appellant Desiree Williams. May it please the court. The record in this case is kind of somewhat minimal because these matters were handled via pleadings for originally for a 12B6 motion to dismiss raised by the appellee, RAJESH and SADHNA, and then became involved with regard to the question of the motions filed by the contractor and the architect. The RAJESH and SADHNA claims that this case is very simple, but basically that this court has to consider the fact that the trial court did not have jurisdiction because of this court's holding in Northeast Neighbors. The problem is, in our mind at least, that the court misfocused on the issue concerning the permit and should have rather investigated to deal with the issue concerning the torts. Meaning
The court should have investigated?
the court should have kind of said there needs for more investigation with regard to the issue of the two torts, the tort of invasion of privacy and the tort of the kind of private trespass. As a result, Your Honor, the question should have been, first of all, that the trial court should not have immediately decided these motions, but rather should have said more time is needed with regard to discovery. Because to this date, no one has any idea as to who were on the patio at the time of these events when these individuals peeked into the bathroom of my client and her daughter. We have no idea whether it was the owners, agents, the contractors, employees, or the architect.
So I guess I'm confused as to what claims you're actually alleging here. You have a sort of throwaway line in your complaint about these people allegedly looking into the window, but your claim for relief isn't for like compensatory damages related to that, right? It's about renovating the bathroom to avoid the issue of the patio still continuing to have a way of looking into the bathroom.
That is not correct, Your Honor. If you look at page 8 of the complaint, the complaint says either A, to redesign the patio, or B, award her compensatory damages of $40,000.
For her to effectuate the design and reconstruction costs for her bathroom to be remodeled.
That's correct.
Okay.
So where is the request for compensation from any sort of peeping Tom?
Well, basically, it would be essentially to say that the $40,000 payment would allow her to redo the bathroom. So as a result, I would think that would be a compensatory damage.
How does that fix the violation of allegedly having people look into her window before that?
Because what would have occurred would be essentially to renovate the bathroom to kind of, there was a skylight, which is the problem here, that these individuals peeked into the bathroom from the patio into the skylight.
Right. But it seems like you are now arguing that there was already some sort of tortious injury. And the question is, what compensation did you ask for to compensate your client for that injury that had already occurred? Right.
The question would be, Your Honor, in our mind, it would be the $40,000 to compensate her to renovate the bathroom. I would think that would be the damage claim that she would be asserting. There is the other question too, that, as I said, the court in this very early motion practice should have dealt with the issue about who were the tortfeasors, the owner's agent, the architect, or the contractor. Additionally, when the court began to investigate the question under the Northeast neighbors, the court should have considered the fact that it was balancing out the question between whether or not it had the right to deal with investigation into the permit or to determine who did what. The court specifically said it had to balance out these two, yet in its balancing factor, it said, I'm not going to deal with this because it's a matter of jurisdiction, and kind of let the other area just slide. So as a result, Your Honor, we believe that for those bases, the court should have done more to investigate, or else this court should remand it back. Because
I think here's what's tripping up. It's tripping up me, and I think it might be tripping up my colleagues a little bit. When I read this complaint, it sure sounds like you're complaining about the design of the patio and not about the peeping Toms. And to the extent you're complaining about the design of the patio, the Northeast neighbors seems to foreclose your claim. The trial court seemed to get that right.
that's correct.
On the smaller slice of this, of sort of the invasion of privacy / peeping Tom aspect of it, can you just, point me to everything that you're aware of in the record, in the complaint, in any arguments that were made, in any motions for reconsideration, just point me to where the trial court was sort of put on notice that really what this claim is about is not the design of the patio. We're concerned about the peeping Tom and we want to be compensated for that. What record citations can you give to me to say the trial court should have been tuned into that question?
Unfortunately, the problem has been this matter was expeditiously resolved via the filing of the motions by the cross appellees to dismiss.
Did you file an opposition?
We filed a response and said very simply, the question the court, Northeast neighbors did not apply, and the court should focus on the question about the tortfeasors, meaning the people who peeped into the unit.
And I'm sorry, I should know the answer to this, but can you point me to where I can see that opposition? Is it with all the different parties? I'm looking at the wrong opposition, I think, right now. If you don't have it at your fingertips.
I think it's 883.
Page 83 of the appendix. Thank you.
The court should have balanced out in our mind. It said, okay, the permit issue, we cannot challenge to investigate. The question should be our investigation into who did what and how do we rectify the problem. The courts clearly said that there were issues that there was an invasion of privacy, there was intrusion into her solitude, and the only question there was the topic as to whether or not a reasonable jury would find such to constitute the tort of invasion of privacy, and to a certain extent also to private nuisance. The court then balanced out and said, well, excuse me, because of the issue in connection with regard to the Northeast neighbors, we're not going to figure out or to deal with the other issue concerning the tortfeasors. That we believe is error. The court would have better taken to better consideration the question about who did what. It did not do that. And that we believe was a major flaw in the analysis. We also believe too that balancing out test was neither logically nor legally correct. The key concern was what happened on the patio. Who did it? We have no idea based on the present record as to who did the actual peeking into the units. And that's a matter of major concern for my client.
So I'm looking at your opposition, and I don't actually see you referring to these peeping Toms or that this is the focal issue. It seems like what you're trying to say is Northeast neighbors doesn't apply because in your view, there's no unlawful use of the permit.
Right. Your Honor, I think essentially that's what I was saying. Maybe it may not be correctly articulated, but that's what I intended to state.
Okay, and so you want us to take a one line in the complaint, which doesn't actually tie to any request for compensation and a lack of that claim in your opposition, and somehow on appeal say that that claim is alive and well and survives an affirmance of the permit questions based on Northeast neighbors.
Your Honor, I'm saying to you that reference in the ad damnum clause says, change the patio, because we were at the time that complaint was drafted. My client nor I knew who was responsible. Obviously, they only sued, my client sued the builder, the owner, and not the builder.
But changing the patio is squarely foreclosed by Northeast Neighbors. I thought you acknowledged that a few minutes ago.
I'm sorry, I don't understand the question.
Anything about the patio goes to the scope of the permit, whether it should have been issued, et cetera, right? And Northeast Neighbors says anything about the patio is foreclosed. You can't bring that to court.
Right, but that was not raised until actually the contractor and the architect presented that. Up until that period of time, neither the appellee nor my client raised that as a concern. With regard to the 12B6 motion filed by the owner, it was only to say whether or not there were legally sufficient grounds to assert claims for evasion of privacy or alleged trespass. Only until such time, if there was no counterclaim filed, this would not be an issue at all. Because essentially it says, A, we deny the claim, and only until after the counterclaims were filed did the issue of Northeast Neighbors come to the forefront. And as a result, we believe that because of those factors, that there should be sufficient grounds to remand this case back to the trial court. Additionally, Your Honor, the other concerns we have is that essentially this case kind of went through very quickly and the proper protocols.
I'm not following that argument. Sorry, you're saying because the contractor didn't bring up Northeast Neighbors, but when they brought in the architect and the general contractor, and they brought up Northeast Neighbors, somehow I'm not following.
My question is, they may have waived that argument until such time as there's the architect and the contractor raised it. Until we were going forward with regard to the.
You think there's a waiver here?
I do.
Where is that in your briefing?
Sorry?
Where is that in your briefing?
I did not raise it until just now, Your Honor.
So haven't you waived the waiver?
I don't think I did, but I can understand the court's concern. Your Honor, also too, as I said, because the fact that this matter went through in a very expeditious manner, the court should have given more time to the development of the record, meaning the issues of normally presentation with regard to 12B6 concerning the questions concerning statement of material facts and other matters. That did not occur here because everything was done in a rather rapid fashion.
Can I get your position on the dismissal with prejudice? Because at one point, appellees say, look, appellees seem to acknowledge if this is a dismissal for lack of jurisdiction, well, then the trial court made a mistake for dismissing with prejudice. It really should have been a dismissal without prejudice.
Correct.
I think that's right. And then your reply brief says something like, that's good enough for us. If you guys will send it back for entry of dismissal without prejudice, well, that will give us a chance to amend our complaint. And we don't need to grapple with exactly, whether or not we've adequately raised this peeping Tom invasion of privacy theory. Is your position that that's sort of relief enough for you?
No, Your Honor, our concern for relief would be basically to remand it back, to deny the entry of judgment on summary judgment, to have the court develop the record better, or as an alternative to say, hey, you know what, do not grant dismissal with prejudice, but rather to grant dismissal without prejudice. We would prefer the former, not the latter, but we were prepared to accept the latter.
Well, I think you should be prepared to accept anything. We don't care that much what you're prepared to accept, but that's helpful. Thank you very much.
All right. Your Honor, with regard to the issue concerning the concerns raised by the architect and the contractor, we understand that they've kind of submitting jointly. We do not believe that that's really a matter for my client to argue to this court, because essentially whether or not there was notice or whatever is not a matter of right here, right now. It would be a question down the road with regard to questions of subrogation, indemnification, or whatever. As a result, Your Honor, we believe that at the present moment, until I hear from my adversary, I would propose that that be accepted by the court. I also require 2 minutes to respond to whatever the owner has to say.
We will give you 2 minutes.
Thank you, Judge.
Thank you, counsel.
May it please the court, William Hayman for the appellee cross appellant Rajesh and Sadhna LLC. I want to speak of a couple things. I think the court is correct that Northeast Neighbors definitely controls this case, and that when one looks at the allegations in the complaint that are found on pages 7 and 8 of the joint appendix, as well as the demand for relief, everything that was alleged relates to the design and the building of this patio. And Judge Paschal correctly raised the issue of subject matter jurisdiction on her own with respect to the plaintiff's claims against my client, which is the owner and developer of this condominium site. She raised it correctly because anyone can raise subject matter jurisdiction. And if the court does not have subject matter jurisdiction, obviously the case cannot go forward. I will also state that this case was filed in July of 2020. And the trial court did not enter its decision until May 27th of 2021. And with respect to the questions concerning what is in the record and all of the statements made about there wasn't enough time or things were too expeditious. First of all, that's a lengthy period of time. Secondly, no one prevented any discovery from being taken. And third, the trial court gave the plaintiff the opportunity to brief this issue.
Can I just take you to the Northeast Neighbors and whether it's jurisdictional or not? You concede in your brief, I believe, that the dismissal should have been without prejudice. And so then what is your view that if we remand for that, that would put your friend on the other side in a position to amend his complaint to raise this peeping Tom argument that we may or may not have now, but he could certainly shore that up on remand?
I completely disagree with respect to the ability to take a case as to which the court did not have subject matter jurisdiction at the time that the case was pled, as the court so found, and then to amend in the same case. That would not be correct, and any
That
allegations.
strikes me as right, but what's your best case for that? Because I mean, I think in an ordinary course, if we were to remand and there was a dismissal without prejudice, there'd be, relation back under like Rule 15, all of that, adding new parties under Rule 17 if you wanted to get the peeping Toms individually as John Does. So I guess I'm inclined to agree with you. I just don't. I'm struggling to get there.
Well, if the court would bear with me for one moment with respect to that argument, what I would state is that I don't have a specific answer to your question.
Okay,
Okay.
I'd like
mean,
you to file a 28K letter if you could, because I am interested in this question of what happens since you both appear to agree on either side that there should be a remand for at least dismissal without prejudice.
But the one point I would make with respect to that, and I would leave it to the court in addition, notwithstanding that statement, given the briefs and arguments of the architect and the contractor, is that the court's decision with respect to whether it was summary judgment, it is a little unclear, particularly because the judge asked the summary judgment issue to be briefed. When Judge Paschal asked for briefing with respect to the permit, she did reference Rule 56. So it's unclear as to what she did. What is clear is that she found that there was no jurisdiction. I realize her order states what it says, which is that the case is dismissed. I would also point out that in Northeast Neighbors, and that was for a different reason, the court said it appeared from Northeast Neighbors that the dismissal could have been with prejudice, but ultimately, if it's subject matter jurisdiction and it's based on a dismissal, then my argument is, and it's not just my argument, it seems to make sense, the court never had jurisdiction, so nothing can relate back.
Well, why would we take that issue up, right? I mean, why would we not just partially affirm and remand to say, you found no jurisdiction, so under UMC development, this has to be a dismissal without prejudice. What happens next? You all can litigate that in the trial court, but it doesn't seem to be an issue before us right now about relating back, about possibly amending a complaint. It's all speculative. Nothing has happened yet.
Well, I think respectfully, it would be helpful to the lower court if we were able to submit a letter, because I'm sure that this issue.
It'd be helpful to the lower court if you submitted a 28K letter to us.
What would be helpful is with the instructions to the lower court, if we submit a letter, because the request has been made in this case on the appeal.
Right, but why would we issue a holding that addresses that at all, right? We review trial court orders. The trial court order in this case said there is no jurisdiction. We could affirm that, but say the results that you reached, having determined that there was no subject matter jurisdiction, you did the wrong thing. You said that this is dismissed with prejudice. The correct response when there is no subject matter jurisdiction is to say it's dismissed without prejudice. What happens afterwards is not before us because it hasn't happened yet. And we're not in the business of issuing advisory opinions, telling people how to manage their business affairs going forward in a way that we can't anticipate.
The only response I would have to that, and I understand Your Honor's point, the only response I would have is that in the brief and in argument, the plaintiff has requested the ability to amend and add these facts, which do not.
We're not in a position to grant a request to amend a complaint here at this Court of Appeals.
I'm aware of that, Your Honor. My only point is that I do believe that this court could give instructions, given that that request was
Do
made.
you have a case for that? Why would we do that? And what case do you have to tell us that we should give instructions to tell people how to respond to events that have not yet occurred?
I don't have a case for that, Your Honor.
Okay.
The court would excuse me for a moment. Unless the court has any further questions, I'm finished with my argument.
Thank you, counsel. Mr. Hartnett, we'll give you 2 minutes.
Thank you. Your Honor, essentially, counsel for the owners raised the fact that there was a substantial period of time between the filing of the complaint and the motion practice that there was a period of time in which between the filing of the complaint and the motion practice done by the architect and the contractor. A review of the docket sheet, which is on A2 going forward, is that for a substantial period of time in 2020, there was the litigation factor going on between the motion between the 12B6 motion raised by the owner, and only until early 2021 was there any kind of beginnings of motion practice dealing first initially with the question of lack of subject matter jurisdiction, in which the court began sending out various orders saying, I agree with regard to the questions concerning the invasion of privacy and the nuisance issue. And then eventually, only when there was the final motion raised by the cross appellees, at that time did she begin to investigate out the question concerning the jurisdiction. At that period of time, discovery seemed to have stopped. There was no discovery propounded by the appellee nor by my client, because at the present moment, we didn't even understand what was truly happening, because obviously adding COVID factors in, this case was in some form of legal limbo. As a result, I think that argument that's raised by the appellees is not valid. We again believe that we would prefer that this court remand this back and deny the motion for summary judgment, or alternatively, has been propounded by both the appellee and myself, that the case be deemed dismissed without prejudice and let the trial court begin to kind of work through all the issues that needed to be developed. I will
Well,
submit.
counsel, it sounds like we're going to get a 28K letter from appellees addressing whether or not an amended complaint can relate back to a claim that was initially, where there was initially a lack of subject matter jurisdiction. I don't know if that's something that we want to get into. I share Judge Easterly's reservations on that point. But if they file that 28K letter, it might behoove you to file a response if you think that you could
I
do
agree
so.
with Your Honor in that regard. Can I ask, when does the court expect the appellee to file his 28-6 letter?
As soon as possible.
Thank you, Judge.
Thank you, counsel. The case will be submitted and this court stands adjourned.